Mr. Ostergren. Come on in and get seated. Do you have a guest with you today that you'd like to introduce?
I do not.
Oh,
I'm sure
okay.
she's a nice person, but
Okay.
I don't know.
Okay. You just walked in together.
Yes.
We always like to give that opportunity.
Thank you.
It's good to see you this morning. When you're ready, you may begin with your opening statement.
Okay, great. Thank you. It's wonderful to be here. Alan Ostergren, Muscatine County Attorney. I want to start by talking about three things and then move quickly to give time for questions. I want to talk about criminal law. I want to talk about administrative experience. And I want to talk about writing. I share the view that given the fact that approximately half of the Supreme Court's docket is criminal law, that it's important to have justices who have practiced in that area. And what I have to offer on that score is 22 years as a prosecutor in the courts of this state, including 3 in which I was cross-designated to prosecute in federal court. I've prosecuted and had jury trials on everything from traffic to murder. As I moved along in my career, I focused my practice on some of the most stressful and difficult criminal cases that we see in our state courts: murder and the sexual abuse of adults and children. Given the work that the court has in direct criminal appeals, appeals of post-conviction relief cases, I think that background is very important for this commission to consider. The current members of the court certainly have had some criminal law experience, some more than others, but there's no one on the court who has quite the kind of background that I have had in prosecuting some of the most difficult criminal cases out there. On administration, the court is, of course, the head of the judicial branch, and I think I have something to offer in that score as someone who has been elected 3 times to county office, who has run an office, managed a budget, managed people. Leadership abhors a vacuum, and I think the court needs to be engaged in the running of the judicial branch, and that means all of the members to one degree or another. There's a lot of work that the court has, and I know it's difficult to balance those things, but to be real frank, we've seen some, I think, examples where the court could have been better. The chief example of that is breaking into county courthouses to test information security. I can assure you Justice Ostergren would have been running around this building with his hair on fire to stop that. And that's difficult to talk about in this situation. I would rather come in here and be all happy and cheerful, but the reality is that was a significant problem, and I think having a court that fully understands its leadership role helps to prevent that kind of thing from happening again in the future. As I said to many of you in my meetings with you, I know how to speak county. Counties are the biggest stakeholder that works with the judicial branch and sharing space, providing space, and I think that would be something that would be invaluable to the court in carrying out its administrative responsibilities. And then the last thing I want to talk about is writing. That is, of course, the main thing that justices do is they write, they explain their decisions. They're the only branch of government that truly shows its work in a way that the others don't. And I have selected for your consideration writing samples that reflect what I can do as a writer. I've picked cases and writing samples that are relatively recent in my career, 2 of which are appellate briefs where I've demonstrated my ability to engage in constitutional law analysis and writing, and in which I'm confident if you were to look at the resulting court opinions that you would see the influence that those briefs had on the court's decision. I want to emphasize something with that, when I say that those writing samples are exclusively my work, I truly mean that. I don't have a team of clerks and associates and whatnot to help me do that writing. I did everything from pull the cases, all of the drafting, all the editing, all the way down to the table of contents and authorities, which if you've used Microsoft Word, you know what an accomplishment that was by itself. So I think writing and the ability to write clearly is an extremely important part of what this commission needs to look at. And particularly, does the court have the ability to communicate the reasons for its decisions so that not just the lawyers in the case understand it, but the public, if they care to take the time to read an opinion, can understand it. It's my goal as a writer to write for that kind of audience, and I offer those examples for you to consider. So with that, that's what I had planned to talk about, and I hope there's some good questions.
Great, thank you. And so we will begin our questions with Mr. Hoiting.
Good morning.
Good morning.
Could you give some thoughts as to what types of cases and how many cases, the type of caseload that you think the Supreme Court should have? What is your opinion about that?
We're getting right into the good stuff here, aren't we? I think the court has a difficult job to balance of focusing on cases of first impression and the things that only the Supreme Court can do, and appropriately sharing the general burden of appellate dispositions with the Court of Appeals. So the numbers are about 110 from the Supreme Court and about 1,400 out of the Court of Appeals. I would personally like to see that number shift towards the fourth floor. Now, I don't know if that means 150 is the right number or 200 is the right number. That's something I think I could only really answer exactly if I was in that role. But I would be an advocate for the Supreme Court needs to take some of the load off of the Court of Appeals. Those judges work extraordinarily hard. And one of the things I would be interested in, the judges all have administrative responsibilities. I think it would be very helpful for the courts, for practitioners to really take a look at what is the screening process. Is it working as well as it could be? When you see cases that are accepted for further review, does that mean that the case is a lot more complicated than when it was first briefed by the parties? Or does it mean that screening process broke down and then you've wasted time in the Court of Appeals having them do a decision when it was going to come to the Supreme Court no matter what? So, that's my thought on that.
Thank you.
Thank you.
Thank you. Ms. Valentine?
No questions.
Right.
Mr. Sukup?
Good morning.
Good morning.
On your terms as a county attorney, you've been very successful at that. What other organizations would you say you've had an impact on?
So I would put out there being elected president of the Iowa County Attorneys Association is something that I'm very proud of in my career, to be elected by my colleagues around the state. We are like a lot of associations where you get elected and then you move up, sort of stair step in the organization, and then it's a 4-year track to become president. So I would say that was probably the most amount of time I've spent in any non-direct work activity. That organization has a significant role in working with the legislature, providing a lot of information, testifying in subcommittee hearings. The year that I was president, we had a very significant effort to fix some problems with how the court debt collection process worked. And I'm very pleased that that was a successful effort. So that, by far, would be the most significant thing that I've done in my career.
Thank you.
Thank you.
Ms. O'Brien?
Thank you. Good
Good
morning.
morning.
Mr. Ostergren, perhaps you could give us a few more details about the fix to the court debt collection process. And my second question is whether Muscatine County or the association has examined the disparate impact that has on African Americans in particular and people of color across the state in terms of their incarceration rate, which is, I think, maybe the second or third highest in the U.S.
So just so everyone understands that when people are assessed fines and court costs and whatnot, shockingly, they don't always pay immediately when they're told to, right? So county attorneys have a role to play in collecting delinquent court debt. The problem with the system before was that the judicial branch had hired a contractor who, if you owed $100 and it went delinquent, the contractor would add $25 to it. So your $100 debt became a $125 debt on day 31 that you hadn't paid it. And so we worked on taking some of the edges off that. We couldn't get that completely fixed with the legislature. So the reforms were to make the system work more effectively, less paperwork, to ensure that the monies are being collected in a way that is fair to the criminal defendants that are in the system. And let me explain a little bit more by what I mean by that. I have 2 people in my office who work very hard on that, and if you have delinquent court debt, a lot of bad collateral things can happen. Suspension of your driver's license, you can't register motor vehicles, all of that. So if you come in, you get on a payment plan, and as long as you're current on that payment plan, then all of those collateral consequences can be taken care of. You get your license back, you can register motor vehicles. We want people to have a license, to have insurance in their cars when they're going to drive, no matter what, right? So I think it's a common sense way to, as long as people are working with us, we're working with them. And so that, I think, helps some of the disparities. I don't think collection of court debt has a direct impact on generalized disparities in the court system. In that, we're not jailing people for non-payment. You can get held in contempt for not paying fines. That's a very tiny slice of what's going on. The incarceration is sort of further up in the process, I would say, than that. And disparities, it's a big challenge for the court, for all the stakeholders in the system. And I think what the court needs to do is send a clear message to all the stakeholders in the system that we need to be thoughtful about how the system works and to be always wary about unintended consequences that can produce outcomes that we don't want, that aren't making anything better for anybody. Thank you.
Thank you. Mr. Berger?
No questions.
Ms. Conover? No questions. Ms. Pearson?
Thank you. When we met, we talked about opportunities for building relationships and just expanding, enhancing, so to speak, images of the Supreme Court. Would you care to share some of the thoughts that you shared with me as to how just outside educational opportunities and such that you stated could be enhanced? Sure.
I think the court is doing a good thing when it has oral argument around the state. I pestered Chief Justice Cady for years to get the court to Muscatine, and I was glad that they came in September of this past year. I think that's a really important part of the court's job that maybe should be more than just a couple or to 3 oral arguments every year. It's a lot of work to put one of those on. I was on the committee to help put that together. But I think the court serves itself and it serves the state well when it gets out in the field, so to speak. We had hundreds of people at Muscatine High School to watch that oral argument, and I can't tell you how good the feedback I got from people in the community who otherwise would never see their Supreme Court in action. I think justice is going to schools after. It worked out very well. My daughter got to see Justice Mansfield come to her government class and pepper him with questions. I think that's really important, and it's one of the things that I would really enjoy if I were blessed enough to be a justice of this court, is to get out of this building as much as possible and get out. You can't lead from an office where nobody sees you. You lead from being out where people can see you and talk to you and see that you're a regular human being.
Thank you.
Thank you.
Mr. Gray?
I have no question.
Ms. Law?
No questions.
Mr. Bevel?
Thank you. Today you referenced your experience prosecuting serious and difficult cases. And, as trial people, when we do that, we're trying to win. Would
Sure.
you agree?
Sure.
Okay. You're applying for a position as an appellate judge. How can I, or why should I, be comfortable with you being fair to criminal defendants?
Sure. I'm glad you asked that because somebody's going to ask it or everyone's going to think it, right? So there's several parts of my answer to that. The first part is a lot of what I do right now today as a prosecutor to be fair to criminal defendants is, to go back to Ms. Pearson's question, that's the part of my job that is in my office at my desk that's not as visible. The public doesn't see me have detectives come in my office and staff a case and me say, yeah, you don't have it. No, there's not enough evidence. This is a civil dispute. Or maybe we'll file a misdemeanor, not a felony. Take your pick. So that part of being mindful of protecting the rights of the criminal defendant is not as visible as the part of my job where we've decided to file a case, I go to court and I do all my lawyer stuff in court to persuade the jury that I'm right. But it's still an important part of my job, and I would say has a big impact on how we administer criminal justice, is setting the example as the leader of we're going to do things the right way. Mr. Spees and I had a chance to talk about this yesterday, in fact, and what I said to him, and I still believe is the thing that I'm frankly more conscious about is, will I be hypercritical of my former colleagues more than anything else? And that is, I understand that the court has to hold the state accountable to follow the rules in criminal adjudication. That, I don't want the rules to be easy for prosecutors. I did not become a prosecutor because I wanted the job to be easy. I expect that when I go to court on a criminal case, it is going to be extremely hard work, and that there are many points on the way that if I don't do my job correctly, we lose the case. And I don't want our system to be any different than that. The answer of, should we make it easier for prosecutors, easier to convict people, you are not solving any problems that you think exist in society if you do that. So I would have high expectations that the criminal cases that come before the court, the people will have done things the right way.
Thank you. Mrs. Sinclair?
No questions.
Mr. Goodman?
Thank you, Madam Chair. Mr. Ostergren, thank you for your application. We have a number of applicants that have touted their criminal experience, some on the defense side, some on the criminal side. You told us today you've been county attorney for 22 years. You've served as president of the County Attorneys Association and also authored, I think, a number of amicus curiae briefs to the state Supreme Court on issues that were concerning to county attorneys. I'm wondering if you can give me a tangible example, because we're going to have to, put some stock in what you've said and other people have said about serving on the Supreme Court with criminal experience and how that would enhance it. A tangible example where a case has been decided by the Supreme Court, and if you or any of the other applicants who had substantial criminal experience were on the court, the outcome would have been either different or enhanced.
So thank you for that question. We have a very difficult to apply body of law on how should a district court analyze a claim that the jury panel that is sitting here for this trial Monday morning, ready to go, does not fairly represent a cross-section of the community. Okay, constitutionally, that's a big deal, right? I mean, that's an extremely important thing for the court system to get right. That the jury panels that we call in are a fair cross-section of the community, and there's not been deliberate discrimination or even negligent discrimination in how that works, how you send notices out, how you get people back into court. As a criminal law practitioner, the cases are very, very hard to apply. And when judges are using terms like margin of error and standard distribution and sampling error, and I can read those decisions and I have enough college statistics to know that they're not using the words right. What they say, the standard deviation is not really exactly right how they describe it. It's an area where and you see just cases that are going back and forth between the district courts and the appellate courts without resolution of these issues, okay? Now, the court needs to, and this gets back to something Ms. O'Brien asked me, I mean, the court absolutely needs to, in terms of deciding the direct appeal, make sure that the jury panel is constitutionally appropriate, and as administration, making sure that our jury selection system works, right? But you also have to decide these cases in a way that it's 8:55 on a Monday morning in a county courthouse, and the panel is sitting out there, and how do we do the math? How do we figure out if this panel needs to get rejected or not? And it is extremely, extremely hard for practitioners and district court judges right now to take those cases and do something positive with them. And the court needs to set that standard, and it has to be a standard that these panels are constitutionally appropriate. But they need to explain how that rule works in a much, much better way.
So you do have an 855 standard? That's my question. I mean, if you're on the court, do you have a way to solve that between 855 and 9?
This is a tough question. I see my lights yellow because, this is truly something where the part of the problem is the court does not collect enough data. The court's getting a little better with that, but when the jury summonses don't require the jurors to mark their race, which is what we're dealing with, then that right off the bat is statistically very difficult. Then how do you get good answers when 20% of your panel is unknown, as an example? So.
Thank you. And thanks for watching the clock. We are unfortunately out of time. Thank you for being here today. We wish you well.
Thank you very much. Thank you, everyone.
You.